Okay, well, let's get going. Thank you all for being here. It's good to see so many of you here tonight. I'm Pat Allman-Rode. I'm one of the co-facilitators of Third Act Lawyers, and it's my great pleasure to welcome you to this webinar on Held versus Montana and the constitutional right to a livable climate. I'll introduce our two presenters in a few minutes, but first a word or two about Third Act Lawyers. We are a working group of Third Act, an organization of experienced Americans, 60 and older, engaged in the twin struggles to protect our fragile climate and our endangered democracy. Third Act currently has about 60,000 members all over the country, organized into both location-based working groups, New York City, Virginia, Las Vegas, the Bay Area, so on, and affinity-based working groups like Third Act Faith, Third Act Educators, Third Act Lawyers, and others. You can find out more about us at thirdact.org. Third Act Lawyers engages its members across the country in pro bono work with organizations aligned with our twin missions. And I'd like to ask Will Carroll, who's coordinating those efforts, to say a little more. So let's see. How do I spotlight Will? There he is. Take it away, Will.
All right, thanks, Pat. So this week's victory in Held v. Montana suggests that climate cases can be a powerful tool for activists to deploy. The cases are being filed with increasing frequency all around the country. Climate cases are especially significant for lawyers who want to use their time and talents to advance the fight against climate change. At Third Act Lawyers, we're working to help our members find opportunities to join this fight, whether it's assisting a team of lawyers in litigation, filing an amicus brief in support of a party's position, or in any other of the many ways that attorney volunteers can support litigants and allow them to deploy resources where they're most needed. And we're not just talking about litigation. Volunteer attorneys can assist with all kinds of potential projects, large and small, including drafting model laws aimed at fighting climate change, drafting comments for submission to government agencies as they roll out regulations under the IRA and other laws, helping to form climate-related nonprofits and assisting those groups with their legal needs, and mentoring and supporting law students working in climate justice clinics at law schools. These are only some of the ways volunteer attorneys can potentially contribute to climate-related causes. Matt may have some specific thoughts about how we can assist our children's trust in particular. And there is a whole realm of pro bono work to address in Third Act's other sphere of activity, as Pat mentioned, which is working to protect our democracy and preserving the critical right to vote. If you are not yet a member of Third Act Lawyers, please think about joining us. If you are a member, think about stepping up to volunteer. We'll be reaching out to you and to learn more about your interests and expertise. And we're looking forward to identify pro bono opportunities for those who wish to join the fight. That's it. Back to you, Pat.
Thanks, Will. And just a couple more things, a little bit of housekeeping. Well, first of all, another thing that Third Act Lawyers does is we host these monthly webinars. And we're trying right now in our programming to alternate between climate and democracy, our two missions. So next month, we hope to have a webinar about democracy, the right to vote, some aspect of that. I doubt, though, that it'll be as exciting as tonight's. But before we get to tonight, just a couple of housekeeping things, like I said. Because you signed up for tonight's program, you'll get invitations to future Third Act Lawyers webinars. And you may, from time to time, get an email from us about something of particular importance. You'll also get a follow-up email after this program with a copy of the Held decision and a link to a recording of the webinar. But we won't sell or do anything else with your information. So just want you to be comfortable with that. As I think I may have mentioned, we'll save some time at the end of tonight's presentation for questions. You can get the jump on that by putting your questions in the Q&A function at the bottom of your screen. And I want to say a special thanks to Seth Weisbord, one of our members, who was the driving force behind tonight's webinar. But even Seth, when he began planning months ago, couldn't have predicted just how timely this webinar would end up being. So now I'm thrilled to introduce Rikki Held, the victorious named plaintiff in the first ever, let's say that again, the victorious named plaintiff in the first ever constitutional climate trial to go to verdict in the United States, and Mat dos Santos, one of the leaders of the indefatigable trial team for this case. Mat dos Santos is general counsel and managing attorney at Our Children's Trust and oversees the legal program which brings climate litigation on behalf of youth both here and across the globe. Prior to joining Our Children's Trust, Mat was legal director at the ACLU of Oregon. They're currently on the board of directors at the Transgender Law Center, Latino Network, and the Chosen Family Law Center. When they're not busy fighting for basic human rights, Mat loves spending time writing music and climbing mountains with their partner Clay and their 2 dogs. I don't know, Mat, will a dog make a presentation of an appearance tonight or not?
One of them is at my feet right now, actually.
So Rikki Held, our other presenter tonight, grew up on a 7,000-acre cattle ranch and saw the destruction of the land and her family's livelihood caused by the changing climate, an experience she feels can be understood by the rural state's ranching and farming communities. While still in middle school, she helped U.S. Geological Survey researchers survey cross-sections of Montana's Powder River, one of the longest undammed waterways in the West, which happens to flow through her family's ranch. This got her interested in the hard sciences, which she pursued in high school and then at Colorado College, from which she just graduated this spring with a degree in environmental science. And since Rikki was the only plaintiff of age when the case was filed, her name will now forever be attached to this landmark decision. Mat and Rikki, take it away. Let me spotlight you. And there's Rikki. Okay.
All right, well, thanks so much.
Pat. Yeah.
Thanks for the introduction, Pat. And Rikki and I are going to be doing a little bit of handing off of this presentation back and forth to each other. And of course, as folks probably realize, we got this decision yesterday and have just had like a wild 24 hours of talking to the media and all sorts of interested folks. Though this is our first presentation post the ruling, so thanks for your grace and your patience as we kind of go through our initial reactions and tell you a little bit about this case and how we litigated it. So I'm going to share my screen, or I'm going to share this PowerPoint presentation, which hopefully will help. Let me see if I can do this without messing it up. Okay. All right. Do y'all see the PowerPoint presentation pretty clearly? Great. Okay, so obviously, just reintroduce myself. My name is Mat dos Santos. I'm the general counsel and managing attorney at Our Children's Trust. Rikki Held, as Pat just introduced, is our lead plaintiff in the lawsuit Held v. Montana, and we're just so happy to be here to talk to you about it. So Our Children's Trust was founded in 2010 when our director, Julia Olson, essentially had decided that after years of advocating on behalf of the environment through the traditional environmental law processes and administrative law, that there had to be a better way. And she really wanted to have a way to take, to take various, government actors to court for the ways in which they were promulgating the systems behind the harms that we were seeing to our environment. And some of this was born out of her frustration of what I imagine lots of us on this call have done, which is challenge projects, challenge permits on a project by project basis, and kind of play the never-ending whack-a-mole that happens in the environmental realm. And so, this idea was born out of trying to take a swing at systemic change. Our Children's Trust, in particular, the organization that Julia founded, was really founded on three basic principles. Which I put up for you. We advocate for and really truly elevate the voices of youth. And we're also bringing cases on behalf of future generations. And what I mean by that, and what we mean as an organization by that, is folks who aren't born yet today. A lot of times, and we'll get into this a little bit, but you hear people talk about the political process and like, why don't you participate in the political process instead of in the courts? I, of course, believe the courts are part of our political process. But beyond that, there are folks that, can't participate. They can't vote because they're under the age of 18. And folks who aren't born certainly can't participate in the political process. And we are, we're really, really concerned about leaving this world that we have habitable for them. And for generations to come. All of our cases are also developed on a sort of simple but not always easy principle, which is that they're always based on the best available science, and that they are always aimed at a legally enforceable and systemic remedy in the court. And finally, and I'll get a little bit into what this means later in the presentation, we are founded on this principle that all of our cases protect fundamental human rights. So the various remedies that we'll ask for, or the various things that we'll advance in our cases, are things that we believe will help like everyone, as opposed to perhaps helping one community while leaving another community out. So right now we have cases in, and I'll get into some of these other other jurisdictions as well, but we have cases, active case in Montana, as you know. We have a case in Utah, a case that is scheduled to go to trial in June of next year in Hawaii, and a case in Virginia that's waiting oral argument. The case in Utah is up on appeal. We have several cases in development. Some of them are listed here. Some of them are actually not listed here. But in Washington, Oregon, Texas, Florida, and Wisconsin, those are some that I imagine we'll be able to talk about more publicly here shortly. But I just wanted to preview this for you, and this actually plays into something that Will said earlier about ways in which you can help, and I'll get to that later. But if you're in one of these jurisdictions, we may want to talk. The other case that is not listed there is Juliana versus the United States, right? And that's the case that many of you may have already heard of. It was one of the first cases that put our Children's Trust on the map, at least publicly. It's a case brought on behalf of 21 youth plaintiffs from across the country who are suing the United States for the United States' contribution to climate change and the ways in which they're actively promulgating a fossil fuel industry, despite the knowledge that that fossil fuel industry is actively harming these plaintiffs. There is another case in development in our sort of federal docket that I saw someone in the Q&A ask about a lawsuit in California. I'm not going to get into too many of the details yet because it's not publicly filed, but There will be a case in California, I think likely within the next maybe even month. And that will, while it will focus on California youth, I expect that it will largely be focusing on federal law in California. We also take cases around the world. These cases, the way that we litigate our cases, especially in global cases, are in partnership with organizations in various global jurisdictions. We do have an attorney based in Europe, in Amsterdam, but most of what we're doing is serving as experts in how to bring these cases and formulate these cases, how to present evidence, how to represent youth, not just how to represent youth as clients, but how to represent youth and applying what we call a trauma-informed care lens to all of our clients who have experienced significant climate harms. And so there are cases all over the world where we partner with local law firms to bring youth cases in their jurisdictions. We also are actively involved in a variety of cases before the European Court of Human Rights. And there are cases that I'm sort of previewing a few things, but there are cases where at the Inter-American Court of Human Rights and the Tribunal on the Law of the Sea that we will likely be involved in here very soon. So just bringing us back to Held v. Montana, this case was filed in Montana state courts under Montana law. It's in the First Judicial District in Montana. It was filed in Helena back in March of 2020. That was obviously over 3 years ago now. This picture is of our plaintiff cohort from, I think this was right before we filed, like pictures that folks either sent to us or we took when we were meeting with our plaintiffs back at the filing of this case. So obviously all of these folks have grown up quite a bit in the last 3.5 years. Yeah, I don't know. I love this picture. It sort of centers me on how this all started. But the complaint that we filed, like I said, we filed it in March of 2020. If you can stop for a moment and think about what was happening in March of 2020, you may recall that at that time, the United States was starting to shut down very rapidly in response to the COVID pandemic. And we had, this was the first case we filed after the COVID pandemic was like being very, very publicly talked about in the United States. And while we in fact were planning on going out to Montana to do the filing in person and had to turn around because of COVID restrictions and other things that were happening. I think it was a winter storm. But the litigating a case during COVID, as I imagine many of you know, has its own unique challenges. And it was really sort of instructive. And one of the things that I'll talk a little bit about during the section where we talk about the trial more is how I think it really, in some ways, helped us bring this case to the public, because the judge over the last 3 years became accustomed to having hearings by Zoom. And when we, decided that we wanted to make this ask of the judge to essentially have the entire trial on Zoom so that anybody could attend, she didn't hesitate. And for folks who have participated in major civil litigation pre-pandemic, you can probably recall that judges were often not very keen on having cameras in the courtroom. And I think that was a big good change. When we think about the intersection of climate and democracy, as Pat put it at the beginning of the hour, we have transparency into our public hearings and our judicial system in a way that I think was not available pre-pandemic. And so while, I think in some ways that is one of the silver linings that came out of COVID. So this map shows us, and this was actually a map that we used during trial. You're going to see a few demonstratives that we used during trial. This shows us the locations of all of the various plaintiffs throughout the state of Montana. Rikki is kind of our lone plaintiff out in eastern Montana in Broadus, and I'm going to let her talk more about that here in a minute. And many of our plaintiffs are sort of either in that southwestern part of Montana, between Missoula and Bozeman, or up in that northwestern part of Montana around the Flathead Lake region and Glacier National Park, all of which become very important to our, to the testimony that they provide at trial and the various pieces of evidence that we showed. What did we challenge? So in the initial complaint that we filed, we challenged several things, but the two biggest statutory challenges that we brought in our complaint were to Montana's state energy policy, and then the climate change exception to MEPA, the Montana Environmental Protection Act. I'm going to pause on the Montana State Energy Policy for a second and just sort of explain for folks who aren't familiar with it, the climate change exception, because it's so important to this case. MEPA, for folks who have done environmental work or permitting work in the national regime or in any, like in California, you would likely be familiar with things like NEPA and other environmental statutes that require things like environmental assessments or EISs, environmental impact statements, for projects ahead of any permit being issued. In Montana, the legislature passed a exception to MEPA that prohibited any agency from considering climate change in the evaluation of a permit. Flat out prohibition to considering climate change. They also prohibited the consideration of impacts outside of the state of Montana. And of course, if you're talking about a pipeline that transports oil and gas through the state of Montana, the impacts that you assess aren't just for that right of way, but they could include, right, like the burning of that fuel somewhere else, the transportation of that fuel outside of the state. There are many ways that you can assess the impacts to the climate of all of these various things like coal mines, pipelines, et cetera. But the legislature in Montana really very heavily restricted the ability to consider impacts of these various permits. And as a result, all permits were issued in Montana. Like every single permit was issued. And this became a fact in trial that we talked about. The state took some exception to that statement. Though, I think ultimately the judge was very clear in her agreement with us in our position. But while there were at times restrictions to, for example, a coal mine expansion, every application was still granted, with sometimes very minor exceptions and sometimes like somewhat more significant reductions, but every permit was granted. On the other hand, renewable energy projects were not often granted. And so we were able to kind of point at the systemic ways in which Montana was really staking their claim on the fossil fuel industry and investing in the fossil fuel industry. And I'll get into that through one of our experts too. So the Montana State Energy Policy, I'm not going to talk a ton about it, but it was initially part of our complaint. There was a flurry of legislative activity in 2023, right before we went to trial, where the Montana legislature, which is a Republican supermajority, started taking aim at the various statutes that we had in our litigation because they knew that this trial was coming up. They completely repealed all of Montana's state energy policy in an attempt to moot the case. The judge granted their mootness motion on the Montana state energy policy. With respect to the climate change exception of MEPA, they made a change to that statute, which in some ways actually strengthened our case, despite the fact that they were trying to make the case go away. And the court allowed us to continue on the climate change exception to MEPA, despite the fact that it had been revised. The state, of course, argued that because the statutory language had changed, that statute was not properly before the court, and they said they wanted to go back and do discovery all over again and like restart the case from scratch, which of course we fought and won. I'll talk a little bit about another statutory act in a bit, but just to preview it, the state of Montana also attempted to limit this litigation and other litigation by passing something which was Senate Bill 557, and 557 took aim at cases that were directed at projects, including like fee shifting, but also basically said that you couldn't that you couldn't invalidate a project based on climate change. And because of the way that the court held with respect to the climate change exception of MEPA, she also found that the new bill that was passed in 2023 was unconstitutional, which was, I thought, remarkable that she included that. So what are the constitutional provisions that were at play? We have several of them listed here. The right to a clean and healthful environment, that's throughout the entire order for folks who take a look at the order. It was really the underpinning to her entire decision. And we're going to talk a little bit about Montana's constitution and how this came to be in 1972. But this clean and healthful environment provision was significant to this ruling in a lot of ways. Several other constitutional provisions were challenged. The right to individual dignity and equal protection of the laws, safety, health, life, liberty, and property, what we think of as due process, substantive due process in federal constitutional terms. And then there was another provision in the Montana Constitution that is in some ways unique to it, that really it explicitly calls out that youth, like folks under the age of 18, have the same fundamental rights as adults. And for folks who have ever litigated on behalf of youth, you may know that in some jurisdictions, that question about whether youth have the same rights as adults has come up. So it was helpful that in Montana, their constitution very expressly said that the fundamental rights that adults enjoy are also applied to youth. I'm just going to quickly touch on Montana's answer. As you can imagine, it's not entirely surprising, but this does play into the trial a little bit. Montana's answer was essentially like a laundry list of denials. They denied things like that climate change was caused by human activity and fossil fuels. They denied all of the climate impacts on Montana that we listed. They denied all of the impacts to plaintiffs. And they also denied all of the allegations that we made regarding the viability of a switch to renewable sources of energy. So I'm going to talk about this in a sort of, I was trying to think about how best to present this in light of the ruling, because I want to get into the ruling right away. And so what I'm going to try and do here is talk a little bit about the testimony that we put on, and then how it showed up in the ruling. So we can kind of go back and forth a little bit in a way that I hope is helpful. But I'd like to start with the impacts to the plaintiffs and plaintiff's testimony, because I think it's really crucial to how we litigated this case and how we litigate all of our cases. And I'll get a little bit into that, but in particular, this, and this is a quote actually from our closing argument, but I actually want to read it because I think it's important. So, what we said in our closing was, in order to acknowledge the full range of harms and constitutional and injuries these plaintiffs are enduring, it's critical that the court address each of plaintiffs' constitutional claims. These are distinct constitutional injuries, and each should be acknowledged and remedied. And part of the reason why I really wanted to highlight that for us, especially as we think about due process, is that often folks get, even really, really good lawyers can kind of get confused around a constitutional case and how injuries in a constitutional case are very, very different than injuries and proving harm in a tort case, right? Like we in our brains, like through our law school training, we are somehow like really trained to think about harms in the context of torts. And in the constitutional context, it's really important to think about them as being somewhat different. And I just like, I think a good example or a metaphor that I've sort of used in the past is when we think about, is it a constitutional violation for like a police officer to search your vehicle without probable cause? And people would say like, oh yeah, sure, of course that is. Like we all know, like you need to, you need probable cause, the officer needs some reason to suspect that you have something to open your trunk and to look into it, right? They can't just go around opening everybody's trunk. That would be a violation of our constitutional rights. Now, the state, in this case, and many other cases, and you'll see people even like within the legal community talk about this, will talk about the harms to plaintiffs as not being individualized, not being different. Like climate change is harming Rikki, but it's also harming Olivia on this picture. Olivia's with the beautiful purple hair, and Eva. But in some ways, like that, like I want you to think back at that example of the search and seizure, right? Like the opening of the trunk can happen the same way to everybody else, but it happens to them. It is an individual constitutional violation when a police officer stops you, opens up the trunk of your car, and searches it without probable cause. And so you kind of have to do this thinking through how constitutional principles play out when we talk about injuries here. But I think it's really important in the context of, like all of us talking about it as lawyers. And so we were really clear that we wanted the court to look at every single constitutional injury and every single harm that the plaintiffs alleged, and as a distinct injury when thinking about everything from their standing to the remedies that the court could present. So, okay, so I've done a little bit of like the laying of the landscape, and I want to turn it over to Rikki for a little bit right now. Rikki testified as our very first plaintiff to go up, which, I'll have Rikki tell you what that experience was like. But Rikki, why don't we just start by you kind of giving a sort of overview of how you got into the case, are involved in the case, and just generally your experience getting ready for trial and testifying at trial.
Okay, sounds good. Thanks so much, Matt.
Sure.
Yeah, so I grew up in southeastern Montana on my family's ranch. There it is. And I kind of got interested in science by working with hydrologists who have studied the river, the Powder River that runs alongside the ranch. And they have data since the 1970s. And so just as a little kid, I would follow them around and help out with their surveys. And I've done internships with them in more recent years. And then just in high school and in college, I've taken more science classes. In high school, I learned about climate change and saw what an important issue this was, and started kind of, along with the hydrologic work, connecting the science with my own home and just kind of seeing the impacts, climate impacts that I've seen just in my own lifetime and changes on my ranch, including like with wildfires and drought, wildfire smoke and flooding and water variability and extreme weather events like stronger windstorms and hail. And so at the beginning of college, my freshman year, just a family friend had heard about our Children's Trust and that they're starting a case in Montana. So I reached out to them, and just on the first Zoom call, they kind of explained what this case was, that it's a constitutional lawsuit, and that as a plaintiff, I would be able to tell my personal story, how I'm impacted, and that, you know, the best available science would be used in this case. So it just sounded perfect to me and really important to do, especially because in our Montana Constitution, we have the rights such as to a clean, healthy environment. And that's kind of a part of our history and values, and just like want us to be a part of that and upholding those. Yeah, and so I guess just kind of going to trial, it was great after 3 years of working on this to finally meet everyone, all of the legal and communications teams and all the other plaintiffs, and to get to testify was just really exciting, and it was great being in our week of court and having all of the plaintiff and expert testimony kind of weave together to tell this broader narrative. And my story is very specific, and it's only one story because everyone is impacted. But I guess to be able to tell it and have the judge listen and have it possibly make a difference on a broader scale is really why I'm involved. And yeah, that's kind of an overview.
Thanks, Rikki. I put this picture in here because I love it so much. It is such a good picture of you. Do you want to just tell folks what's going on here?
Yeah, I wanted to try bronc riding at least once, and I stayed on for about 4 seconds before getting bucked off. But yeah, it was really fun. It was actually very relaxing being on the horse, surprisingly. That was a lot of fun.
That surprises me.
Yeah, it's kind of just in slow motion. Yeah.
Yeah. And then this is something that you testified about, and was one of the impacts that I think came up quite a bit was the impact of fire on Montanans, and of course smoke. And so I wonder if you could just like quickly summarize kind of some of the stuff that you talked about to the court during your testimony about this fire.
Yeah, and just to put it more broadly, I guess like sometimes I talk with people and ask them if they've ever experienced any climate related impacts, and usually they say no. But so it's kind of important to think about our personal stories, because everyone's affected by things like wildfire smoke, and that we get air quality alerts, and that affects our ability to go outside and recreate. And with ranchers, it's really important because we're outside all the time, just taking care of the land and livestock and crops. And even though my family, we aren't primarily doing the ranching, we're leasing out right now. I'm still like out here in summers doing maintenance, fixing fence or whatever, and or cleaning rooms at the motels we have in town. And you just kind of have to keep going on with daily life, even with we had some 110-degree days when I was out working, and air quality alerts from wildfire smoke. And so yeah, I kind of got to testify to that and talk about a few of the fires that have affected us, even if they're not on the ranch. They, burn. This one fire burned 70 miles of power lines, and we're out of electricity for a few weeks, and that affected our ability to get water up to cattle in the hills, to the tanks, and just with other impacts like years of drought that affects the grazing, and cattle have to walk farther between the water and grass and feed, and yeah, it just impacts them. And with water variability or less snowpack, that affects the water we have in reservoirs and hills to keep cattle fed, and it all kind of ties together. And it's yeah, it's been interesting kind of being a part of this case and be able to make that connection, especially coming from a ranching community.
Thanks, Rikki. And I know you talked a little bit about this, so maybe there isn't more to say about the Powder River, but one of the impacts that I think you talked about specifically was the sort of well, I'll just let you re-say what you said.
Yeah. Well, yeah, here's the Powder River, and kind of looking on our ranch, it's to the right. And obviously water is important for a ranch. If you irrigate it from it, or we have pivots that uses the groundwater. And so with more water variability, we had the river dry up one year enough to where it stopped flowing. And we've had floods that, like undercut banks and fences and all these things. And we just very much rely on water. So when it's more variable and uncertain, it's, just kind of hard to know what to do.
Thanks, Rikki. So, and I'm going to go through some of the other plaintiff harms, and of course, Rikki, just jump in with anything that you want to add. So, as I said, the clean and healthful environment was part of the kind of core of our case, this constitutional provision in the Montana Constitution, and we, part of our strategy around the way that we litigated the case was to really tie individual harms from each plaintiff to each constitutional provision. And so in our, everything from our pleadings to the way that we presented plaintiff testimony, we really made sure that we carefully sort of thread the needle of specific injury from each plaintiff to the constitutional provision at play. So here's just an example of some of this and some of the various folks who, had impacts from the clean and healthful environment, though there were more. One was, you see Kian was one of our plaintiffs, fly fishing, who had impacts to their ability to fly fish through things like river closures or toxic algae that were impacting fish. Grace talked about specific impacts at Glacier National Park, and in particular Sexton Glacier, which it was melting, and in fact, there's a lot of testimony about how Glacier National Park's glaciers just are no longer there. Rafting, so recreational uses of rivers. Skiing, Claire was a ski instructor, so in addition to recreational use, she had income that she lost because of changing weather patterns, which we had experts testify to. We also had a public trust claim, which, as many of you likely know, they're a doctrine that is in many constitutions throughout the United States is the public trust, and that's that the government holds natural resources in trust for the public. And so we really tried to illustrate ways in which Montana was not adhering to this constitutional requirement. Some of the things that we talked about in these contexts, again, so here you see Georgie, who is a competitive skier, and she testified to the ways in which snowpack was depleting, and she had restricted ski seasons. She's on the river there. Some of the rafting or river closures were impacting her ability to use rivers. And then these are the two on the left are Lander and Badge, who are two brothers who were plaintiffs who talked about their access to hunting. They in fact hunt for most of the meat that they eat throughout the year. And fish. And so they had concerns about their ability to hunt and fish declining. So another constitutional claim that we brought was under the individual's rights to dignity. And in Montana, this also was, their constitution is, I think, very clear about the way that a dignity right should attach to folks. And this is another statement from our closing, talking about, in particular, these plaintiffs who had their right to practice cultural and spiritual beliefs were being violated. And these plaintiffs here are Sariel, Ruby, and Lillian, who are all Indigenous youth in Montana who were part of the case. We also had, a claim around equal protection, and explicitly, right, as I said earlier in the Montana Constitution, that folks under the age of 18, like fundamental rights attached to them, and that we alleged that the state of Montana was not protecting young people as they were required to do, both under the equal protection clause and also under the clause that I mentioned earlier around the children under the age of 18. This I just included quickly because I thought it was a powerful statement from Micah, one of our plaintiffs, who is a competitive runner and who has had a number of, their running seasons cut short, has developed, had issues with breathing and wildfire smoke, et cetera. But really here, Micah is talking about the in some ways the mental health impacts of climate change on them and during the COVID crisis. And I think some of the ways in which young people are despair because their government is not protecting them and they don't believe that they have adults who are helping them. And one of the things that I think is really noteworthy about these cases, right, is that the plaintiffs have, as Rikki said, an opportunity to go and testify in front of a judge even if Rikki had not won, Rikki would have still had the opportunity to be heard in a court of law, which is powerful and empowering. And so we think that this is an important part of why youth participate in these cases. So the court made a number of findings. The decision which came out, which it was 103 pages long, really got into a lot of our evidence in detail, but I've listed a couple of findings here that were relevant to plaintiffs' harms. In particular, that, and I think importantly, that the youth plaintiffs were disproportionately harmed and would bear the brunt of climate impacts much more so than adults, in part because they would be living for longer, but also in part because their bodies are still developing and they're uniquely susceptible to things like wildfire smoke, like their young lungs, et cetera, which our medical doctors will testify about. And the judge really, the state often argued that a declaration would do nothing, right? And we said that's just simply not true. There's all sorts of things that a declaration of constitutional rights would do, which we can get into a little bit. But in part, it does go to meaningful redress of plaintiffs' injuries, right? As the court here found, because it is, in addition to simply acknowledging the harms that are happening, the court trusts that the government will respond to this order and the injunction that she issued. I'm sorry, well, yeah, the executive and the executive branch agencies will respond and follow the law. So some of the expert testimony, and actually, I just want to clarify, I should have moved this around a little bit. We had one fact witness outside of the plaintiffs, really, and that was Maynann Ellingson, and she was the youngest delegate to the 1972 Montana Constitutional Convention at the time that the Constitution was drafted in Montana. And as I imagine many of you know, there is somewhat of a conservative legal movement around textualism, right? That we're hearing a lot about in the federal courts and in other state courts. And so it was important to us to really get someone who could talk to what here the framers, right, the founders of the Constitution meant. And because Montana's Constitution was created in 1972, we were able to find somebody who was literally there. And I mean, honestly, this is Maynann's testimony was just so incredibly powerful because she was also the delegate that wrote the clean and healthful provision of the Constitution, so she could speak to very clearly what was intended when this was proposed. So this was the proposal that she made, right, which was that each person would have a right to a healthful environment, and that each person has the responsibility to contribute to the preservation and enhancement of the environment. This gets put into the Constitution, and Maynard takes the stand and testifies as to what it means, including that she had said, and I don't have a slide that shows this, but we showed this in court, that at that time, she said that she anticipated that this provision would eventually go to the courts to decide the scope of what a clean and healthful environment could include. And Judge Seeley, in this order, decided that a stable climate was within the scope. This is just a picture of Maynard at the time signing the Constitution. Dr. Running, Stephen Running, is a scientist in Montana who helpfully presented the court, educated the court, and really the public that was watching on climate science in a pretty profound way. Dr. Running talked about a bunch of things, including the Earth's energy imbalance, greenhouse gas emissions, and how they're driving climate change, and really that it's human caused, right? And that human caused those human-caused harms are having all sorts of harms to Montana, from everything from water to all of the ecosystem services that we rely on as people. And then, of course, they talked. Dr. Running talked about how it was harming the plaintiffs themselves. The expert report was co-authored by Dr. Running and Kathy Whitlock, Dr. Kathy Whitlock, and they sort of shared this report in a way that I thought was really effective for the court, which was Dr. Running talked about kind of the big picture of climate change and climate trends and explained climate science, and then Dr. Whitlock really drilled into how that mattered to climate change how that mattered to the state of Montana. And so this theme of, right, like the state would say things like, oh, well, like even if humans are causing climate change, Montana's contribution is insignificant. Montana is just like a piece of the puzzle, et cetera. Like they tried to essentially say like, well, there's nothing we can do about it. And of course, we disagreed and had our experts say many things that suggested that there's plenty that each individual jurisdiction can do, and that it would in fact require jurisdictions, all jurisdictions, to do what they could. One of the really important things that came out of Dr. Running's testimony, and really came out throughout the rest of the expert testimony, was that that in order to have a stable climate, we need to reduce the carbon dioxide in the atmosphere to 350 parts per million. And I'm happy to talk about this in more length at some later time, but a lot of times we hear about like the temperature targets set by Paris. We don't think those are useful legal targets in a lot of ways, because they leave a lot of a lot of communities out of the picture, right? Like island nations, et cetera, that will be ravaged by climate change if the world remains at 1.5 degrees Celsius. But also because it's like a much harder target, right? Because you're talking about these like global averages in temperature. And so like the Arctic can be warming at 6 degrees, where the equator can be warming, or the average can be 1.5. This overall, we think the science is in agreement about this, that the standard and the most helpful standard for courts to consider is this target about the concentration of carbon dioxide in the atmosphere. Sorry, that was this was just at the end of their expert report, really talking about how that judicial intervention was essential, right? And that is a theme throughout all of this case, that we really need the courts to intervene in Montana. And the judge agrees, right? Here are some of the findings with respect to Dr. Running, which is that really importantly, that each additional ton of greenhouse gases emitted into the atmosphere exacerbate the impacts of climate. And then I'm not going to read all of them. You can take a look, but essentially the conclusions that the court included were very much based in expert scientific testimony, which I think is profound and will have meaningful impacts on other cases like Held that are being litigated currently and in future cases. I'm going to sort of go through this a little bit quickly. But some of the stuff that Dr. Whitlock talked about specific to Montana and the changes that was being experienced in Montana had to do with rising temperatures, the change of precipitation, and the amount of rain and snow. So timing and location of precipitation, it sounds so like unimportant in some ways, but like when it snows and when it rains actually matters a lot to ecosystems. And so we had scientists talk about that and how those changes would have meaningful impacts on the plaintiffs. Also, here you can see like where the plaintiffs are located and the increase in days of what we call extreme heat between, projected out at 2070 to 2099. This is something that comes from, folks will be familiar with it, the UN's Commission on Climate Change. And so this is one of the various pathways that that commission considers. And you can see just in the increase of extreme heat, especially in areas in Western Montana, in Eastern Montana. So essentially that one of the conclusions that the climate scientists testified about was that that Montana had to act, and they had to act now, and they had to act very quickly to decarbonize in order to stabilize the environment. And I think we did this intentionally, but like we wanted to both talk about the urgency, but also not say like it's too late, right? I think that sort of there's all sorts of reasons why that's just not true scientifically, but also I think it's important for the court, right, to be able to act, to understand that this kind of ruling would have an impact in the future. And it's not, all of this climate catastrophe is not inevitable. So here's some more of the court's findings with respect to the climate science specific to Montana, and how the court talks about the fossil fuel emissions in Montana contributing to the exposure that youth plaintiffs have to climate harms. Just being sort of conscious about time, I'm going to keep going, and I'm going to go a little bit more quickly here. Dr. Faegre, Dan Faegre is this amazing glacier scientist who cataloged all of the glaciers in Glacier National Park and does some really incredible photography on them, but talked about the various ways in which Glacier National Park is experiencing climate change, and how the future of Glacier National Park is to be glacierless, right? Like there's just all of these glaciers are receding, and you can see it really clearly in some of the scientific papers that were introduced into evidence through our experts, many of whom were authors on these papers. But here's, you can see where these glaciers were in the 1850s and where they are in 2015. And frankly, we just didn't have the data ready for 2023, but they would be much, much worse, right? Like the glaciers are receding even farther. I'm going to skip the rebuttal points because those ended up not coming into play. So again, like Dr. Faegre talks about the decrease in snowpack and the scientific consensus around glacier retreat. We had a freshwater ecologist testify, Dr. Stanford, who talked about the impacts of climate change to freshwater ecosystems. And now remember, tie this back to the plaintiff's harms, right? Rafting, fishing, so recreation and like food sources, along with other ecosystems that come into play because of the importance of rivers and fresh water. Rikki, of course, testifies about rivers in her testimony, in the variation in water and water reliability. So Our freshwater expert testifies about it, and the court then concludes, right, that that climate change is having significant impacts on both the water that we see on the ground, right, like through rivers and lakes, as well as changing in precipitation patterns, drought, etc. Michael Derglo, who is an important part of the Confederate Salish and Kootenai tribes, talked about the importance of climate change to indigenous traditions, and this became a really important part of our trial. And in fact, we put all of the various we had a day really that was just entirely dedicated to the ways in which climate change was harming indigenous plaintiffs and indigenous the tribes in Montana. And and so I'm going to go through this a little bit quickly, but this is something that that Michael Derglo wrote, but talking about the overwhelming scientific consensus about how it impacts the tribes. The court takes Mr. Derglo's testimony and puts it in as one of the findings, right? Like that for indigenous youth, the climate change concludes in harms that really reduce their ability to practice very important cultures and traditions. Dr. Lisa Van Susteren was a clinical psychiatrist who talked about the harms that climate change has on the mental health of youth, and really looks at the ways in which climate change was having harms on mental health and mental health outcomes overall. And here's a piece from the American Psychological Association that talks about the ways in which climate change is impacting mental health. This was a powerful part of testimony that then the judge includes in the order, right? Talking about psychological harms that lead to not just immediate harms, but harms that are enduring throughout the life of that child, and how the harms that you and I experience as adults are different in this way as well. Dr. Lori Byron was a medical expert who talked about the various ways in which plaintiffs were harmed physically, right, through through climate change. In particular, as I talked about earlier, Dr. Byron talked about air pollution and how it was harmful to forming lungs, to young lungs, and how the various ways that climate, like heat, extreme heat, would have worsening impacts on children who are experiencing them today, not just today, but throughout their lifetime, and how if we dramatically reduced our fossil fuel use, it would have immediate benefits. And that's something that I think often kind of gets missed in this conversation, is that there are immediate localized benefits to the reduction of fossil fuel burning immediately on health impacts and health outcomes. I'm going to just sort of scroll through this quickly, but this was some of the evidence that we showed around air quality and air quality getting worse in Montana over the years. And this one was just looking at air quality and impacts and, right before the pandemic happened. These were some of the conclusions that Dr. Byron had, but that this is how they were worked into the order, right? That all children, and this was just so important for this order, even folks who were not already harmed, right, like with pre-existing conditions or illnesses, are uniquely sensitive to climate change because of their developing bodies. And that really, I think, helped buttress the constitutional claims that the judge found. We also presented expert testimony about the energy transition because we wanted to be very clear about how feasible it was to transition to sustainable energy, and that Montana had the resources to do that. And also that Montana's contributions to, and this is true, especially true for Pete Erickson's testimony, Montana's contributions were meaningful. And we looked at this in a variety of different ways, but like we showed how, for example, a population of 1.1 million in Montana had the same fossil fuel consumption numbers as Ireland, right? So a much higher per capita fossil fuel consumption number. When you looked at the ways that fossil fuel were burned for purposes of transporting and processing, they had a bigger footprint than Colombia, a country with 52 million people. And this is a state of 1.1 million. And this came back to this theme that was throughout the entire trial, which was that every additional ton of carbon dioxide that was emitted into the atmosphere adds to global warming, and that every additional ton that is stopped now has a meaningful impact. And so, you know, the sort of Pete Erickson's testimony really got at that, right? That what happens in Montana matters, and that it is just as legally, like it is just as important legally for Montana to stop as it is for, you know, the United States, even though there may be different, or China or other countries that have bigger footprints. But some of the things that the judge really honed in on, and I think it shows how the presentation of that evidence really worked for the judge, which was, you know, she finds that that Montana's consumption of fossil fuels was disproportionately large, right? And that only 5 states in the United States have a greater per capita emissions. She also finds that the overall, so this 1.166 million tons is consumption, transportation. It's the entire spectrum of fossil fuels in Montana is the equivalent of you know, the emissions from Argentina, the Netherlands, or Pakistan, some of which have, you know, that Pakistan has 248 million residents compared to Montana's 1.1. So when the state is saying what Montana does doesn't matter, you know, we're showing how they compare to the rest of the world. Dr. Mark Jacobson talks about the transition and its feasibility in particular. And I'm going to sort of skip through this really quickly because I didn't actually include a couple of the slides that I wanted to on accident, but essentially talks about the viability of Montana's available resources, right? Like Montana has an incredible amount of wind, water, and solar resources available for a transition away, and all of Montana's energy needs could be met through a transition to sustainable energy sources. Sorry, I'm skipping right to the conclusions. So the judge agrees, right? The judge finds in this order that it's technically and economically feasible. And really in a big way, right? Like 80% of the fossil fuel energy could be replaced by 2030, and 100% could be replaced by no later than 2050. But as early as 2035. That comes directly from our expert testimony, which she includes. And then they also talk about she also includes in her order the amount of money that Montana would save by doing this transition, right? Because a lot of times people will talk about how much it will cost. And she explicitly talks about how much money Montana would save. And Ann Hedges, who is this amazing advocate and has worked for MEIC in Montana for ages, talks about the various ways that the state had been like promulgating fossil fuels. This was really important testimony, and it ties into like our overall sort of story of the case of how Montana is responsible for these harms. And in particular, you know, she talked about the knowledge that Montana had going into the decision to exclude climate change from its decision. So this is a document back from the Department of Environmental Quality in the early 2000s, where you know they talk about how the reduction of greenhouse gases would be a stimulant to the economy, not a drag on it, right? Like in direct contradiction to what the state was arguing today. They also talked about the establishment of the need to establish reductions in greenhouse gas emissions. And this was, 20 years ago. Meanwhile, today, right, the state is expanding coal mines. They have one of the largest coal reserves in the world, right? And they're expanding coal mines, and this is important for this case, right, at the exclusion of any consideration of impacts to climate change. So, sorry, I didn't mean to skip over this. This is the amendment that I talked about earlier in the presentation that the legislature passed in 2011 that made it so that agencies conducting environmental reviews could not review actual or potential impacts beyond Montana's border, and could not include actual or potential impacts that are regional, national, or global in nature. So, i.e. climate change. Their amendment in 2023 actually explicitly, it removed the regional, national, and global in nature and just replaced it with the word climate change, which was, I'm still confused why they did that. I think it made our case easier. This was another example of one of the many examples that we put forward of the permits that were issued and expressly said, we would have considered climate change, but we're not allowed to because of the state of Montana. So the court includes a lot of findings in response to that testimony, including that the state of Montana is known about greenhouse gas emissions and the danger that they pose for years, and that that statute, the MEPA limitation, was essentially hamstringing Montana agencies from complying with this provision of the Montana Constitution of the clean and healthful environment. And therefore, right, as she says here, they could have prevented the infringement of plaintiffs' rights, but instead they infringed on plaintiffs' rights. And lastly, but I think so important, it says that the state's actions are exacerbating anthropogenic climate change and causing harms to Montana and its youth. I'm going to just quickly touch on Dr. Haggerty, who didn't testify because their economist. So this was in court, right? The state decides not to put up their economist for all of the things that they talked about in their expert report. So, but Mark Haggerty would have talked about how undercut Terry Anderson, their economist's assertions that essentially, by ending fossil fuel burning, we would be harming Montana's youth instead of helping them. But that was one of the themes of their arguments going in, that they just essentially backed away from completely by the time the state put on their case. And just for folks who don't know this, we put on about a week's worth of trial testimony, and the state only put on a day. And we expected them to put on a full week, and had a full week scheduled for trial for them. These are two folks. Sorry, I will just quickly say who they are, but Dr. Barrett, who's an economist who was going to speak on our behalf, and Dr. Trenberth, who's a very famous climate scientist, who was going to rebut their expert, Judith Curry, on climate science. Neither of them testified because the defense never presented their climate scientist expert in a move that still is in some ways baffling. Did the defense case really sort of boiled down to three witnesses: Chris Dorrington, who is their DEQ director; Sonia Nowakowski, who is at DEQ; and Terry Anderson, who was an economist. And one of the things that was written about in response to Chris Dorrington's testimony was, during his testimony, Chris Dorrington, and mind you, this is the head of the state's Department of Environmental Quality, said that prior to the litigation and really prior to trial and being prepared for trial, he had never heard of the UN IPCC. He had never heard of the UN's a document that comes out that talks about the harms of greenhouse gas emissions to the climate. And this is the person who is in charge of permitting all of the fossil projects in the state of Montana. It was a shocking moment in trial for him to admit that, but I think, you know, really showed the way that Montana has been burying, you know, its head in the sand about the impact that it's having on climate and on youth. So important takeaways from the trial, and then I will stop and answer questions. So one of the main conclusions, right, is that Montanans, but of course our youth plaintiffs, have a constitutional right to a clean and healthful environment, and that right underpins all of these other rights. This right to dignity, their due process rights, equal protection under the law, and public trust rights. And those were all infringed by Montana's fossil fuel permitting regime. The court acknowledges the unique harms, so the ways that youth are disproportionately impacted. And the court enjoins the state of Montana, issues an injunction saying that they can no longer, that those statutes are unconstitutional and they can't take unconstitutional action, including ignoring greenhouse gas and climate change, and also the constitutional rights of plaintiffs. So, you know, what's next for the case? The state of Montana has been very public in saying that they are going to appeal this decision. And while we don't know for sure, we expect the argument timeline to be, like, briefing to be done at the end of this year or early January. And that arguments would be in sometime early next year, early 2024 in Montana before the Supreme Court. You know, frankly, I think we have an incredible record of trial, and I'm excited to go to the Supreme Court in Montana. And yeah, and so I will, I'll just quickly say this and then I'll pause for questions, because Will sort of teased this at the beginning. There are lots of ways to support us. A couple of ways that really quickly came to mind to me is that we often need volunteer attorneys to help us with amicus briefs, to help us with research projects. And so, you know, you could be in touch with me, or just email the info at Our Children's Trust. My email will be up at the end. But you know, I'd love to hear from people who are interested in supporting our work and volunteering as attorneys with us. Also, in any of the jurisdictions where I've mentioned, and of course, yeah, like there are other jurisdictions that we're doing initial exploring of now. We would love to be, if you have connections in those jurisdictions to partners that you think we should be connected with, we'd love to hear from you too. And of course, I, you know, would love it if folks became donors at Our Children's Trust. All of our work is done for pro bono for all of our clients, and most of the funding that we have comes from individual gifts, from individual donations, not big foundations or grants. And so the becoming a donor is just like a tremendous way to support the work of Our Children's Trust. So I'll pause and take questions, and I'll leave this up here that has my contact information for you.
Matt, thank you so much. There's a lot to digest. I hope we get the, can we get the slides?
Yeah, I think so. I may take a couple of them out, but yeah, because there are, I mean, as I said, some of this was done very quickly in adjusting to the order, but I think I could give you the slides.
Great. Well, there are a whole lot of questions in the Q&A, most of them from Matt, so I want to take the host privilege and ask Rikki a question to start off with here. Rikki, what was the most impactful or most like moving or most frightening for you moment at the trial?
Yeah, I guess just one thing first that I was really excited about was to have all of the expert testimony and the climate science put on record. And yeah, just listening to all that was great. But also it backed up our stories on what plaintiffs were saying. And so, yeah, it was great to have it in court, but just kind of going through what we've already known, and this has been going on for a long time, and we've known for so long, and it's been a part of our history, and just how much it is impacting people. And yeah, I guess just listening to my fellow plaintiffs testify, like Micah's poem was up, and there's a lot of moments where like people are like very vulnerable and emotional. Yeah, so I guess, yeah, there were some heartbreaking moments, but overall it was just really good to get the information out, and to let like those stories be heard.
Yeah, thank you. Matt, there's a question. Are there any groups similar to OCT that are focused on disabled plaintiffs who are heavily impacted by climate change? Do you know of anything like that?
So, I mean, in some ways, I would say I think that we are unique in that we're representing youth, and of course, we are representing youth with disabilities, and it is something that comes into our cases. I think a lot of there are some groups in Europe that are more focused on folks who are like at the end of life, right, and who have disabilities that are come up from that. And I can't remember the name. All of a sudden, I'm sort of frustrated that I can't remember the name of that group. But they have litigation right now. I think it's in Sweden. I'll look it up while we answer some other questions and answer that question. But you know, I really think that we are going to continue to bring the voice of youth, including disabled youth, to the forefront, because it is a community that is very vulnerable. But I don't know of a specific one in the United States that does climate litigation on behalf of disabled adults and youth exclusively.
Yeah, thank you. There are a couple of questions that are sort of generally on the theme of precedential value. What
Sure.
what influence is this case going to have outside of Montana?
Well, I mean, I think that we're already seeing some of that happening live, right? Like just the attention that it's gotten at the global stage has been pretty phenomenal. And I suspect and hope, right, that the influence it has is sort of a few fold. One is that that litigators outside of our Children's Trust who are litigating these cases, especially in Europe or in the global South, will really consider changing the legal hook for their cases to 350 parts per million instead of relying on Paris, because Paris, I just think unequivocally isn't a human rights standard. It doesn't protect island nations. It doesn't protect a lot of marginalized communities and coastal communities. And so really want to see a shift away from using a temperature target to something that's like this measurable target that's based in science. But I also think that, frankly, I think this is the case will have value because judges look to what other judges are doing. And this order in its sort of breadth is really amazing. And I think it will give other judges courage to take steps where maybe they didn't want to be the first. Right. And so my hope is that we see this case cited in other cases very soon, even if it's not binding precedent.
Yeah, well, we can only hope. There's an interesting question. You guys relied on expertise that you drew from, all kinds of sources. Do you know if there was support of any kind, financial support in particular, from the fossil fuel industry, more broadly speaking, the support to the state? Were you fighting against the whole industry or just the state?
We were just talking about this last night. Interesting. Like Julia and I were talking about this. The fossil fuel industry and RAGA, the Republican Attorney General's Association, has showed up in Juliana. They tried to intervene in that case, were sort of partially successful. The fossil fuel industry stayed away from Montana. your guess is as good as mine as to why, but I suspect that part of the reason was that the attorney general and governor there, who are relatively new, meaning they were elected in the last 2 years, just didn't think through this strategically, right? They assumed that this case would go away. They were litigating it as if the case would just go away. And I think they, kind of got caught a little bit surprised. And so some of the things that we might have expected from a more sort of choreographed top-down approach just didn't happen in Montana.
Yeah. Okay. Well, good for you, right?
Yeah.
Good for us. Yeah.
Yeah.
We are just about at the top of the hour, so we certainly understand it if folks need to drop off. But Matt and Rikki, if you can stay for a few more questions, that'd be great.
Sure.
Terrific. Thank you. So it's sort of a general question here. How did plaintiffs get selected for the case?
Yeah, I think Rikki talked a little bit about this, right? Like she heard about it from a friend.
Yeah, just family friend.
Yeah. And then we do, I think, pretty standard plaintiff intake, right? Like we have a call with a plaintiff like Rikki, and Rikki could probably recall the call that don't talk about the contents of the call. Rikki, admonish you to not waive your attorney-client privilege. But we have conversations with the plaintiffs. We ask them about their impacts. We ask them about where they're located. We essentially assess the viability of their claim based on a number of factors. We also are really deliberate in who we bring into cases, meaning that we want plaintiffs who represent youth in a kind of broader way, right? That where we realize that Rikki can't speak on behalf of all young people, and just like Sariel, Ruby, and Lillian can't speak on behalf of all Indigenous youth in Montana, but by bringing plaintiffs with really clearly distinct backgrounds, geographic locations, and harms to the case, we think we set up the judge for appreciating the many ways that the state was harming plaintiffs, and we really wanted it to be clear. So like how we select them is a little bit of a combination of luck and instinct on like what will make a strong case for the jurisdiction.
Right. Rikki, couple of questions for you. First of all, were you the first plaintiff to testify? Is that right?
Yeah, that's right. I went
How did
on
that feel?
Monday. It's good. It's nice to get over with. But yeah, I guess it was good because I could kind of go first and kind of see what the state's strategy was. They, for the most part, decided like not to cross-examine plaintiffs.
Wow, really?
Yeah, and they objected to one thing, just because the question was about mental health and I couldn't testify to that. But yeah, for the most part, didn't ask plaintiffs questions.
Wow. And another one here, how have your local friends and neighbors responded to your involvement in the case? The questioner writes, I imagine they aren't used to local people having quite such a high profile. Are they supportive, interested, questioning, something else?
Yeah, like I've just gotten support. There hasn't been anything but support, and talking with some people in Broadus about like doing some kind of lecture or like town hall meet kind of thing, or but it's been great, and talking with people around here about it.
That's really terrific. I'm glad to hear that. There's a question, Matt, how can we contact a lawyer working on the forthcoming California case?
Just reach out to me, or like maybe CC info@ourchildrenstrust.org to make sure that it does. Right now my inbox is it's difficult to navigate. So CCing info out will just mean that somebody else will make sure that your message gets seen and forwarded to me.
Great, great. Now, one of the things you've said is that one of the keys, maybe in some ways the key to your case, is that Montana had this explicit provision, has this explicit provision in its constitution, or a couple that you relied on. Do you know if there are groups working to get those kinds of provisions inserted into other states' constitutions?
Yeah, I mean, there are, including folks like 350.org and folks that you all are familiar with at Third Act. I think that there has been kind of an ebb and flow of people interested in doing what is, sort of called green amendments, in part because I think at first people didn't, so there was like a cynicism around them that we obviously didn't share, that they were not useful, that they were just like flowery language. So but I think that if anything, I am hopeful that that's one of the other impacts that this Held decision will have, which is that it will encourage people to go out, petition their government to make those changes, especially in states where amending the Constitution can be done by like ballot initiative, et cetera. I mean, that's not work that OCT will do, but I suspect that other groups will now start to mobilize those efforts even in more earnest.
Right. Well, that'd be terrific. Rather specific question here. The questioner writes, if I recall correctly, your diagram of international cases showed one in Africa. What country, what court, what theory?
Okay. Mabazi is a case in Uganda. Wow, I'm doing power of recall now on the spot. It's against the Attorney General and the National Environmental Management Authority in the High Court of Uganda. It essentially, the complaint there is structured differently than we think of our complaints, right? Like, of course, we work with a local Uganda attorney, and it is it's structured to look at two of the articles in their constitution that protect the country's atmospheric resources from climate change, but it's really a public trust kind of case. So those two articles, if I'm recalling it, and I'm sorry, I might be messing this up, and you should definitely go to our website and look at the ongoing legal actions and look at the Uganda case under the global cases, and there's a description there. But essentially it is looking at the atmosphere as a public trust, which is one of the sort of early theories that our Children's Trust was deploying, both in states as well as in other countries.
Yeah, great. So I think maybe this is our last question. You must be tired, Matt. And Rikki, I'm sure you have better things to do too. So you talked about this a little bit already, but say a little bit more about your prospects, or what you think the prospects of success are in the state Supreme Court. And do you have any kind of specific hints, either from the court or from the state, already?
Yeah, I mean, look, I'm a litigator. I'm bullish. I think we're gonna win at the Supreme Court, but I think that there are also good reasons for me to think that way, right? Including the fact that we have this incredible record before the court of all of this testimony of plaintiffs, expert witnesses, that gets included into an order that's 103 pages long. The state puts on 2.1 witnesses, right? Because their economist was really narrowed in their testimony. And we'll see what their legal theory is, but I imagine that their legal theory is going to be based entirely on like, this case should have never gone forward. It should have been dismissed on standing. But you see how the judge really tries to be careful about connecting plaintiffs' injuries to state action. And I do think we have gotten hints from them. The state has tried to go up to the Supreme Court a couple of times. These are slightly different, you know, obviously procedural posture attempts, but but one of the times, actually both times recently that the state went up, the court very summarily, without even allowing us the time to respond, rejected the state's attempt to derail the case. So, I mean, I think the other thing to think about too, and you know, I typically am somewhat circumspect about saying this, is I think that the state attorney general is not doing himself any favors by going on, you know, if you look at the media about our case, they put out this terrible statement that essentially calls the whole thing a political stunt, calls the judge an ideological judge, which, by the way, Judge Seeley, we were not sure what to think of her. And throughout, she played a very moderate, maybe even conservative approach. So Judge Seeley was not like giving us win after win that we thought we should have. And so, but the AG has been very public in its attacks of the Supreme Court and the judiciary just generally in a very kind of MAGA Republican way that I think is not going to help them. I think the Supreme Court is not very happy with them. And I think that that this careful opinion by Judge Seeley is likely to really insulate her from being overturned by the Supreme Court.
Wow, well, that's terrific. Thank you. So we're at the end of our program. Matt and Rikki, thank you so much for being with us tonight. Thank you for the work that you've done. Congratulations on the result. We will certainly be watching and helping as we can. And I just want to thank everybody for attending tonight. Watch for a follow-up email. We'll send a copy of the decision itself, and we'll send a link to the recording, and who knows what else. We'll just send some other things as well. Got them. And that's it. Thanks very much, everybody. Oh, once again, special thanks to Seth Weisbord for setting this up. Good night, everybody.
Thanks, everyone.
Yeah, thank you. Thanks for all the work you guys are doing.
You're very welcome.